And now to Jay and to Lynn. We're going to have some questions. And the way this is going to work, folks, is I'm going to direct a question to one of you and then ask the other member of the panel if they would like to weigh in with some thoughts of their own, and then we'll just go back and forth as time permits. So, Jay, you ready? I have a question for you.
Okay,
has the current commission been more prone to issuing affirmative injury determinations?
Well, if you had asked me that question in December 2019, I would have said, well, so far it looks that way. If you go back to, I don't know if you can go back to my slide, it's one of the slides with the list of the ITC determinations, but I believe the first 10 or 11 decisions reached by the current makeup of the commission were affirmative. But looking at cases from January 2020, in that span of time, the ITC has issued 9 cases, and it reached, actually made negative determinations in 5 of them. So, it's still early, but I would say overall, no. It looks like, the ITC is, does a good job, from my standpoint. They're a very professional, independent agency, and they seem to historically they seem to be fairly balanced in terms of their affirmative and negative determinations. And so far, I'd say that this commission doesn't appear to be any different. I would note, though, referring back to one of my comments, that amendment to the statute that prevents the ITC from reaching negative decisions solely because the U.S. industry was profitable or had an improving performance over the POI. I noted one of the cases where the ITC cited that provision and made an affirmative decision, even though the U.S. industry had a gross profit rate of 40%. But there were other cases where the ITC cited that provision. So it'll be interesting to see if over time, that provision does lead to more affirmative decisions.
Thank you for that response, Jay. Lynn, do you have any thoughts on that? The current commission more prone to issuing affirmative injury determinations? Anything to say about that?
Well, I guess the one thing I would add to what Jay said is that provision he referred to it'll be very interesting going forward. We had an experience with softwood lumber proceeding where the domestic industry was also very profitable, and that did not impact ITC's determination. They still made an affirmative determination. So it will be interesting to see how that provision plays out in the future.
Okay, Lynn, don't go away because I have a fresh question for you. This person writes, I am an importer. How do these developments affect me?
Well, I'll speak to the commerce developments. One of the impacts of any countervailing duty or anti-dumping proceeding is that they increase uncertainty in the market, because it's always unknown what the ultimate resolution of these cases will be. And I think that some of these recent developments, particularly in the anti-dumping and Commerce's administration of the anti-dumping and countervailing duty proceedings, is that it tends to increase this uncertainty, and as I indicated in my presentation, can potentially result in increased duties which an importer has to pay.
Fair enough. And let's give Jay a chance to chime in on that. How do developments affect importers in your view, Jay?
Yeah, I would agree with Lynn. There have been recent developments that Lynn discussed in her overview that, on the whole, tend to give DOC more opportunities to find dumping and margins and subsidy rates. So, I would agree that that creates uncertainty for importers and also increases the likelihood of affirmative decisions by Commerce.
Okay, let's go to a fresh question for you then, Jay. In ITC cases involving multiple countries, Does the ITC always consider the combined impact of imports from all the subject countries?
Not always, but nearly always. So again, there are, two main bases for an affirmative decision. The ITC can either find that the U.S. industry was presently injured by the subject imports, or it can find threat of injury. For present injury purposes, the ITC almost always, very rarely has the ITC considered or decided not to conduct an aggregate or accumulated analysis of the subject imports from all the subject countries combined. The ITC's practice is to consider four main factors: whether the subject imports from the various countries are fungible or interchangeable, whether they were sold through the same channels of distribution in the U.S. market, whether they were sold in the same geographic regions in the U.S. market, or there's at least overlap, and whether they were sold during the same points in time or over the same months. And looking at these factors as a whole, the ITC need only find that there's a reasonable overlap of competition between the imports from the various subject countries in order to conduct accumulated analysis. So it's a very low standard, and as a result of that, for present injury purposes, the ITC almost always does conduct accumulated analysis. For threat, however, the standard is different. The ITC has a little more leeway to conduct a decumulated analysis or look at the subject imports from one of the individual countries. So in a threat case, the ITC has discretion to accumulate. And in addition to those four factors I cited, the ITC also considers whether imports from any of the subject countries are likely to compete under significantly different conditions of competition than the imports from the other subject countries. And this tends to give the ITC a little more leeway to conduct a decumulated analysis.
Okay, thank you for that, Jay. Lynn, unless you have a comment about these ITC cases involving multiple countries, which Jay just addressed, I have a fresh question for you. What would you prefer?
Well, I don't really have anything. Jay presented a very thorough response, and I don't really have anything to add to that. So
very good. So then let's go to a fresh question for you.
To a new question.
Good. How significant do you think the new currency undervaluation regulations will be?
Well, as I indicated, these just came into effect in April, so we really have not seen Commerce issue a decision under these regs yet. The thing that is very striking about these regulations, however, is how much discretion Commerce gave itself. The regs repeatedly refer to what Commerce normally will do. It's actually striking how many times they use that phrase. And so this, suggests that giving them so much discretion, again, causes, sort of going back to my earlier theme, causes a lot of uncertainty and increases the risks for exporters and importers going forward.
Fair enough. Jay, would you like to comment on that, or I can give you a fresh question?
Nope, that was a good answer.
Okay, so then, Jay, a question for you. Does the EAPA give Customs CBP the authority to investigate circumvention of AD/CVD orders?
Well, that's kind of the question. That's kind of what I was discussing in my presentation. Technically, circumvention does mean something different under the statute. So the answer is no. EAPA does not give Customs the authority to investigate circumvention. That's a decision by to be made by the Department of Commerce. But the question raised by the Diamond Saw Blades case is whether, by virtue of Commerce making an affirmative circumvention decision, can Customs use that as a basis to find evasion? So that's really the question, and it becomes really one of timing, because if you think about it, so in the Diamond Saw Blades case, a key issue or a critical issue is that DOC's circumvention decision wasn't effective until, or was effective as of December 2017. So as of that point in time, Commerce is saying imports of diamond saw blades from Thailand that were manufactured from, key components made in China, as of December 2017, those are subject to the anti-dumping order on China. But Customs, in its EAPA investigation, it said that, so certainly going forward from December 2017, any imports from Thailand of diamond saw blades made from components sourced from China, if the importer made those imports but declared that the country of origin was Thailand and thereby avoided the anti-dumping cash deposit, no question, that's evasion as of December 2017. But Customs did not stop there. Customs said in the Diamond Saw Blades case that evasion also occurred prior to 2017. So that's really, a key issue that, again, is before the Court of International Trade right now, and it will be very interesting to see how that develops.